Let's get back on the record then. Back on the record, State versus Bryan Kohberger, CR 29222805. I was explaining how the order and the scheduling conference might go, at least my plan. And so I'm going to start with you, Mr. Carone. Your clients have the motion to vacate the amended non-dissemination order filed May 1. Also the motion to intervene filed May 1, same date. And now this case is in my hands, so I need to set a hearing. And I'm wondering how far out. I'd like to get some briefs, and this is a message to everybody before the hearing, including I want to hear arguments about whether or not there should be cameras in the courtroom in a high-profile case like this one. So, Mr. Carone, what looks good for you? And let me throw out, knowing that a lot of you were prepared to be here the week of June 26, that might make sense. But I'll hear from you, Mr. Carone.
Yes, Your Honor. So with our motion to vacate, motion to intervene, we've briefed the merits issues there. I think, as the court's aware, we also briefed those issues before the Idaho Supreme Court, so I would think we could be ready to move pretty quickly. We have not briefed the issue about video cameras in the courtroom, so if that's something that you'd like the media coalition to weigh in on as well, we would need to submit a separate brief on that, but we can do that in the week of the 26th. The 26th itself, I'm not available, but the rest of the week would work.
Excellent. And I'll tell you, the reason that I'm bringing up cameras in the courtroom is because if I address that issue, and I haven't let you all know that that might be an issue, then I'm going to get a lot of grief for not allowing you to brief that issue. So that's why I'm giving you an advance notice on that. How do you feel about the afternoon of June 27? Given what's happening just quite recently, we might want to do that in person. I'm willing to do it remotely, but then we have to, there are a lot of different interests and different people who want to weigh in on that, so it might be better to be in person. But does that work for you, say starting at 1:30, June 27, Mr. Carone?
Yes, Your Honor, that works for me. And Ms. Olson and myself can both come in person. We would have been there today in person, but we found out about the in-person option on Friday, so I apologize for using Zoom today, but we can certainly be there in person. If the court's anticipating hearing from witnesses that day to hold an evidentiary hearing, there may be some witnesses that would want to appear via Zoom if that's okay with the court, but I'm not sure if that's even something you're contemplating. I'm just flagging it in case you are.
Well, let me put it this way: it's your motion and others' motions, and one of the complaints that I've seen in the briefing is that there's no evidence in the case supporting any of it. You know, we're all kind of moving forward on supposition, I guess. And some of it is obvious, but I think that would be wise. I suppose you could just file declarations, and that's what's been how that's been going. I might, if we're going to have a lot of testimony, I might want to move this back to 10 a.m. just to make sure that we have enough time to get things finished that day. Would that work for you?
Sure. So our position on the evidentiary issue is, your summary was correct, that we don't believe that there is an adequate factual record at this point. Given that it is our motion and it's based on the record that existed when the order was issued, procedurally I'm not really sure there is an opportunity for additional evidence be put forth. I only brought that up because I saw in Mr. Kohberger's opposition to our motion for reconsideration that there was a mention of an expert witness. If that evidence was going to come forward or other evidence, we of course would want the opportunity to cross-examine that individual or whatever individuals might be testifying. But, you know, as things currently stand for the record as it exists and the evidence that the Media Coalition intends to put forward, we included a declaration with our motion. I'm not sure there's really need for us to put on additional evidence, but if that's something the court was going to hear from the state or Mr. Kohberger, then I just wanted to bring that to the court's attention.
Thank you, Mr. Corona. Of course, you'd have the opportunity to cross-examine any witness. All right. Well, we'll stay at 1:30 then. So now, Mr. Gray. So I'm thinking that maybe we should keep these things together and do them the same day if that works for you and your clients.
Well, Your Honor, I see the issue very clearly different from the AP's motion versus my motion. I think their motion is more of a getting rid of the non-dissemination order, the gag order. My motion is a motion to amend and or clarify some of the issues in the gag order. They have a lot of constitutional different issues that we have. I have some issues that I think are very separate. So I would request a hearing on my own much sooner. I think the court's aware I filed this motion in February on this case, and there was a massive delay based on the fact that previous judge, Judge Marshall, was waiting for the Supreme Court to get some clarification regarding the AP's motion that she filed with the Supreme Court. So I'm ready to go when the court's ready to go, but I think our issues are very, very different than that of the AP's motion on this case. So I would request a hearing much sooner I can do it by the end of this week.
All right. Well, and I recognize this was all pretty short notice for everybody. And I don't know if, let me go to Mr. Rudley and then Mr. Logsdon, because they're going to weigh in on that motion as well, I'm assuming. I'm thinking about maybe June 9th would be the soonest I could do this, but let me go to you, Mr. Logsdon.
Your Honor, we'd be ready to go and would expect to put on an evidentiary presentation for that week of the 26th. To the extent that Mr. Gray wants to have his motion heard ahead of time, and just based on what I've read in it, I mean, obviously, if the court were to agree with some of the things that he says.
Into the mic, I guess.
Sorry. Obviously, if the court were to agree with some of the things that he says and winds up amending the order, that could change everything for everybody else. So to some extent, I think it actually is probably better to do them all at the same time, so the court isn't in piecemeal changing what we're all arguing about. But I would be ready for the 9th if the court chose to do it that way.
No judge likes to do things piecemeal. But I also understand that Mr. Gray and his clients have been waiting for a long time now. It's not anybody's fault. It's just how that came down, because the Associated Press et al. Went straight to the Supreme Court in February, early February, and that would trigger a delay, which it did, and it was important, I think, for Judge Marshall to get the direction from the Idaho Supreme Court before we start, chipping away at each order. So I don't know if would you be. I mean, I'm okay setting it for June 9th, Mr. Gray, but you may have some testimony happening. You may want to wait until you hear what everybody else is saying. It's likely that there's going to be some adjustments, you might say, or clarifying in the order. Partly in my reading of the Supreme Court's decision, maybe I'm reading too much into it, but there were some hints maybe of what the trial court might want to consider. Okay, go ahead, Mr. Gray.
I was going to say, since this is your gag order now, this non-dissemination order, Your Honor, and in reading my motion, if the court does want to consider making some of the modifications that might have been suggested in my motion, my motion may end up being moot. I think some of my modifications and or clarifications to the non-dissemination order are fairly minor, but allows, and I think the Supreme Court did give some guidance, which I think added weight to my arguments and my motion. So it's not above the court to take a look at my motion as well as any other motions that have been submitted to the court and modify the non-dissemination order, allowing for some of the issues that I've discussed in my motion, and then you would only have the AP who are attacking, I think, the gag order as a whole, the non-dissemination order as a whole. I'm just addressing a couple of clarifications and amendments that would allow myself as an attorney to speak on behalf of my clients that regarding the non-dissemination order. And I think it's your order now, so you're more than apt to be able to go and make those changes, and then we wouldn't have an issue with the non-dissemination order at all. So I don't think that's, so obviously the 9th, I'd like to keep the 9th because my issues are very small and narrow regarding that non-dissemination order. But if you were to make changes to those ahead of time that I was able to review and it was acceptable, I would withdraw my motion, Your Honor.
Okay. Thank you, Mr. Gray.
Thank you.
Well, it would be highly unlikely for me to change the order before I hear from counsel, because I don't want to, third, fourth, fifth, sixth. I only want to do this once, and I'm happy to set it for June 9th, maybe 10:30. Does that work for you?
That does, Your Honor.
Okay. Does that work for you, Mr. Rudley?
Yes, Your Honor, it does.
Okay. Mr. Logston?
We'll make it work, Judge.
Okay. Let's do that in person. Okay. So now we have the June 9th at 10:30. We also have the Associated Press et al. On June 27th at 1:30. I assume that works for you, Mr. Rudley?
It does, Your Honor.
Okay.
Yes, Your Honor.
Okay, excellent.
Your Honor, may I speak?
Yes, Mr. Corona.
Your Honor, I apologize. I may have misunderstood what you said earlier. I was understanding that the week of June 26th was when the court was first available, but if the court is available to hear our motion earlier, we would be available on June 9th as well. I know that our most recent motion is pending more recently, but obviously we've been challenging this since February as well. And it's our position that the non-dissemination order violates the Associated Press and Media Coalition's First Amendment rights. Those constitutional violations are irreparable. So we would like our motions to be heard as soon as possible as well. And I suggested otherwise by agreeing to the week of the 26th. That was simply because I misunderstood that was when the court was first available.
Thank you. Only one thing I'll say about that. Irreparable harm goes both ways. And so I was a little bit troubled by that claim without considering the Sixth Amendment considerations. I mean, this is a balancing. The law is clear on this. Okay? It's a balancing test. And when your client says that he's arguing it as the First Amendment is absolute, is also troubling. So I would suggest that maybe the Associated Press needs to tone it down, just ratchet down a little bit. Because some of the arguments, including the first line in the motion to intervene, says that the Supreme Court held a certain thing, that I do not think that that is what the court held. And you know the difference in a holding of an appellate court. So I just felt obligated to help you out a little bit in terms of what the Associated Press is asking for. And in the meantime, there's a lot of potential irreparable harm from media that is affecting a fair trial. So that is really concerning. This is a very high-profile case. So I'm happy to set this on June 9th, too. Okay, how about we set yours at 1:30, though, so we don't kind of push them all together. Does that work for you, Mr. Rudley?
It does, Your Honor.
Okay, does that work for you, Mr. Logsdon?
Your Honor, I don't know if we'll have an evidentiary presentation ready by the 9th. That would be my only concern. We can certainly try, but
Well, let's see, and if that doesn't work out for you, then
we'll let you know.
we'll talk about it. Okay, I just felt the obligation to talk about irreparable harm. Okay, there's a lot of interest here, Mr. Carone, and I think my job, my constitutional responsibility is to consider all of the potential irreparable harms, or all the injuries, or all the harms. So, I just want, maybe it's appropriate, I was just thinking, I just want to remind everybody, okay, on this particular issue, but all issues, at all times, that we all, okay, judges, lawyers, journalists, media generally, have constitutional responsibilities to both the First Amendment and the Sixth Amendment. And what I generally am seeing in the newspaper and the media is no discussion about the importance of the Sixth Amendment. It's just the First Amendment, which is very important. But here's the real reminder. The first sentence of the preamble of the Idaho Rules of Professional Conduct says that a lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. We all have that responsibility. And sometimes we push in a hard way for our clients, and that's appropriate. But you have larger responsibilities at the same time. Okay, so we got a hearing 10:30. That's for the Gonzalez family with Mr. Gray. 1:30 is the Associated Press et al. With Mr. Carone. And I think that deals with all the pending motions. For you, Mr. Gray, you articulated what your motion is. So we've addressed that.
Thank you, Your Honor. Yes,
Okay.
yes, Your Honor.
You're welcome. And Mr. Carone, those two issues that are still outliers on your clients, I think that's all we have. The motion to vacate the amended non-dissemination order and the motion to intervene. Anything else that we need to address for your clients, Mr. Carone?
No, Your Honor, unless you mentioned the broadcasting issue as well. I'm not sure if you're going to set a separate briefing schedule for that. Obviously, for the motions, they'll follow the briefing schedule wasn't going to follow that yet. I just didn't know when exactly you wanted that briefing.
I'm going to send a briefing schedule out for everybody. And now, okay, if we're going to do it on June 9th, you don't have very much time to do those briefs. So that's why I was thinking it made a lot more sense to do it at the end of June, but if you all think you're ready to do that, I'm willing to hear it. But I want those briefs. We'll say by June 2nd. Response briefs will be due by June 6th, and any reply briefs due by June 8th. So that's going to be rapid briefing. I'm just trying to accommodate everybody. Okay? I got a lot of interest floating around on these issues. Without forgetting Mr. Kohberger, who's primary in this case right now. All right, so let's move to, and I mean, anybody who's here for Associated Press or Gonzalez family can be excused if you'd like. We're also happy to have you stay. No problem.
Thank you, Your Honor.
Okay. Thank you.
Thank you, Your Honor.
Okay, thank you, Mr. Farrell. All right. So what we have now between the parties is motion to compel, which we're moving out. That was kind of a on and off hearing. Disclosures of grand jury materials while protecting those materials from the public. Extension time to file pre-trial motions after receiving materials from grand jury. I believe those are the motions that we have outstanding. Is this, are you arguing these or scheduling these, Ms. Taylor?
Your Honor, we can schedule all of those hearings.
Okay, when do you want me to do this?
Your Honor, I think that if the court has June 26th, we can do that. We will be ready to address that round of motions on June 26th.
Excellent. Well, how about 1:30 on June 27th, because the Associated Press moved that to the 9th.
June 27th is just fine for us. Your Honor.
Okay, perfect. Well, 1:30. Okay. Is there anything else we need to address today? Mr. Rudley? Mr. Thompson?
Your Honor, I think the June 27th should work fine. For whatever reason, our office hasn't seen copies of the grand jury pretrial motions, but I think there was a miscommunication. Those will be coming. We'll be prepared.
Okay, great. And certainly if those issues are resolved between counsel, then we won't have to have a hearing.
Yes, sir. Thank you.
Okay? So anything else we need to address today, Ms. Taylor?
No, Your Honor. Thank you.
Okay, thank you. Mr. Watson?
There, thank you.
Okay. Great. So I think Ms. Mastiff has been observing on Zoom. I just wanted to identify her, and also Ms. Let's see. Oh, I guess Ms. Beatty is too. So anyway, there are other people on the Zoom. So thank you. Okay. Anything else then? No. Okay. Thank you all.
Thank you,
We
Judge.
are adjourned.